corporate prosecutions are not just about imposing large fines. What prosecutors have been doing over the years is imposing very substantial compliance reforms on banks through these resolution agreements. And I think the point that's been missed sometimes is that these obligations, I think it's fair to say, are not just paper obligations. They are not just window dressing. In some cases, prosecutors have imposed not only obligations that are very costly in terms of hiring new compliance officers, but also they have gotten some of the largest banks in the world to abandon entire markets. HSBC agreed to get out of several countries that were considered to be high-risk countries. It agreed to review all of its payment orders throughout the entire world for compliance with US law on sanctions, which means that they are now essentially implementing US law on sanctions more broadly than the law itself requires as a result of that agreement with DOJ. So the point that I'm making is that to think about the effectiveness of these resolutions, you can't think only about deterrence and whether we're punishing the right people and whether that seems satisfactory in terms of criminal justice objectives. But this is also a policy tool that is effectively being used by the United States to turn these banks into implementers of US policy, including on sanctions, including on tax, everywhere in the world. And that is an important consideration. It's something that can't be done through prosecuting individuals, as some of the critics have suggested is central.